This lecture is for the Law of Contracts, CCRI, Spring Semester 2020, the Monday night session from 7 to 9:30 at the Flanagan campus, and this is the third section and final section for Chapter 13, which deals with third parties. Another type of third party is a third party beneficiary. Another term for these folks is an intended beneficiary. There are many types of contracts where the two people who are entering into the contract and are the principals intend that part of the consideration, part of the benefit, is to go to a third person. The most simple type of this type of agreement would be it's Mother's Day coming up and wanting to be a good son. I call the florist and I order a $50 bouquet of roses to be sent to my mother on the afternoon before Mother's Day, so that she gets these roses and she sees what a nice, wonderful son I am. The contract is entered into between myself and the florist. However, the intended beneficiary of the performance by the florist is not me, it is my mother. In those types of situations, the courts have long held that if the florist doesn't perform, I certainly, as one of the primary parties to the contract, could sue for damages. And secondarily, the courts have held that if I'm not interested or too busy or don't want to sue, that possibly my mother could sue for damages because she did not get what was supposed to be going to her under the provisions of the contract. On a larger scale, a life insurance policy is very often a third party beneficiary contract. So I have a wife and children. If something happened to me, they would not be able to survive without my income. I enter into a contract with the insurance company and make a provision that should I die, my wife is to receive a set amount of money. I'm not the one receiving it. I'm going to be dead. I could have said my estate would receive the money, but there are lots of reasons why I don't want that to happen. I want the money to go directly to my wife. So in this situation, I and the insurance company are the primary makers of the contract. We are the primary parties who are obligated under the agreement. However, the entire purpose of the agreement is to give benefits to my wife directly to her. I am still an owner of the contract. She is not necessarily, although with insurance it can get very complicated. We could have situations where we would make her the owner. But the idea is here that the insurance company and I have entered into this agreement. It is a binding agreement. We are the principal parties, and the entire purpose of the agreement is to give benefits to someone else. If I were to die and the insurance company refuses to pay my wife, she absolutely positively would have every right to get a lawyer and to go after the insurance company to get the payment that was agreed to as part of the contract. There are situations where a party who is not directly an intended beneficiary could still end up suing as a third party beneficiary. In your textbook, they give an example of someone who owned a condominium, and the people in the unit above them consistently over a period of a year or two cause water to flow out of their tub or their sinks, whatever, and cause damage to the condominium below. The person in the unit below sued. Now, I would have sued in tort, which maybe they did, but they also sued in contract, saying that they had a right as a member of the condominium association, as a unit owner of the condominium, that they had a right to sue to make sure that the rules and regulations for the condominium, which every owner was required to sign up for and to agree to participate in, that they actually gave them intended beneficiary rights. That since the people above them were not maintaining the rules, they were constantly flooding the plumbing and causing damage to the unit below, which was absolutely against the rules of the condominium, that these folks now have the right, using the contract agreement between their upstairs neighbors and the condo association, to sue. And in that particular case, the court held that they were absolutely right, that they could go forward on a contract basis. I think that's actually kind of a stretching of things, but that's part of the reality of what happens here, and that shows how a good lawyer thinking on their feet can come up with some ideas to stretch the law and to create situations that will give their clients the ability to recover when they may not have otherwise been able to. Question always arises as to when do the rights of third-party beneficiaries come into being. Now, if I decide to buy flowers for my significant other and to send them to them, and I say, well, I'm going to send them to them 2 weeks from now when it's their birthday, and during the interim we have a fight and we're not speaking to each other, and I decide to cancel that agreement, does the third party, my significant other or maybe former significant other, do they have any right to still receive the flowers? And in most situations, the courts would hold that unless it was specifically written into the agreement that the third party acquired immediate rights, that all rights remain with the original two parties until such time as performance should have been made to the third party. So if I did not cancel the contract after the birthday came and went, then my significant other would have the right to go after the florist for not sending the flowers if they didn't do that. But prior to that point, if the provisions of the agreement allowed me to cancel before the delivery date, I could cancel the third-party beneficiary. They didn't even know of the contract, but even if they had no right to stop me from terminating the agreement. Same thing would work very often with an insurance policy, that if I'm not under any court order because of a divorce or some other situation to maintain life insurance for my spouse, I could set up a policy, I can make the payments, and if I decide I don't want to do that anymore, I could cancel it without my spouse's signing off or without their permission in most situations. The rights of the third party, again, usually accrue at a point in time when performance should be done on their behalf. If the performance is not done, then they have the right to sue. Or if they were written into the contract from the very beginning with it expressly being stated that they have acquired rights into this situation. And there are certain annuities and there are certain insurance policies that have provisions that give immediate rights to third parties. But again, that usually doesn't happen automatically. It's something that has to be contemplated between the initial parties, and very often the third party has to be aware of or have notice of that for it to be effectual. The law does not allow what are called incidental beneficiaries to recover. An incidental beneficiary is somebody who might gain benefit from the contract, but they were neither one of the original parties, nor was the express intent of the agreement to give them any benefit. An example that I thought of was that the city contracts with a contractor to build new sidewalks and to put all of their sidewalks and their corners in accordance with the federal regulations concerning handicapped accessibility and handicapped accommodations. The contractor accepts their initial payment but then refuses to finish the job and leaves 2/3 of the sidewalks in the city still not handicapped accessible. Anyone who is a handicapped citizen of that town or city would have been getting a benefit by this contract being completed, and they were even, in a certain sense, the contract was intended for them, but it was not directly written to exclusively benefit them. It was written in order to get new sidewalks done for the city. The main two parties of the contract in the city, and I would say in a case like that, most courts would hold that even though it does affect them incidentally, the handicapped citizens would not have the right to sue if the city did not decide to go forward against the contractor. All right. Usually, in order to be able to sue as a third-party beneficiary, you have to show several things. One is you have to show that the consideration, the performance of the contract was intentionally, deliberately meant to go to benefit you, the third party. Sometimes, if you have the right to control details of the contract, that in itself is a showing that you are a beneficiary, in a certain sense, I would almost say you're a party to the contract at that point, and therefore you could enforce your rights even though you may not be the one paying the consideration for the contract. And if the contract specifically states that a person is to benefit, then again, they are a third party beneficiary. They'd have the right to recover. All right, that wraps up what I have to say about Chapter 17. I will be posting my lecture on Chapter 18 in a few days, so keep looking on Blackboard and on YouTube for that. And I will be emailing you through Blackboard and through your CCRI emails just to keep up with what we're doing with the course. All right, have a good evening.